Greetings, good people. Today we are going to talk about discrimination. Everyone has the right to work in an environment that is free from harassment, bullying, and discrimination. Discrimination on the basis of race, gender, age, religion, or other protected attributes violates someone's right to be treated with respect, dignity, and fairness. Bullying, harassment, and discrimination can damage the affected person's well-being, work performance, and job security, and it can be destructive to a business by creating a negative workplace culture. It can expose an employer business to direct liability, where the business engaged in the discrimination or various liability for the discrimination engaged in by one of their employees, where the employer cannot show that they took reasonable steps to prevent the discrimination from happening. Discrimination happens when you are treated less favorably than others because of a personal attribute about you rather than your ability to do the job. It is unlawful to discriminate against someone due to their protected attributes. For example, race, color, national attraction or social origin, sex, gender identity or sexual orientation, age, physical, intellectual, mental or psychiatric disability, pregnancy or potential pregnancy. Marital status, relationship status, and family or career responsibilities, a religion, political opinion, trade union activity. Examples of discrimination occurring in the workplace can include job refusal, being dismissed or having shifts cut down, denial of training opportunities, transfers, and promotions, not being paid the same as someone doing the same job with the same experience and qualifications, exclusion or isolation by co-workers, having information you need to do your job deliberately withheld, being given impossible tasks, being subjected to taunts or abuse that references the protected attribute. Examples of workplace discrimination. Discrimination may be intentional or unintentional, direct or indirect. Discrimination can come in the form of jokes and offhand comments that seem harmless to or even go unnoticed by the perpetrator. The below the examples that show some of the different ways in which discrimination can occur in the workplace are: Mary is 6 months pregnant. After 10 years working at an accounting firm, she applies for a senior position that has just opened up. Despite having more experience and qualifications than the other applicants, she was passed over. When she asked the manager, he said, "I need someone who will be more dedicated to the position." Example number 2. Ryan works on a construction site. His co-workers recently found out that he was gay and have started calling him Princess. Another example: Annie works in a toy store and has a physical disability preventing her from carrying heavy items. She recently found out her co-workers earn more than her despite having the same experience and working just as hard, When she asked her manager about it, she said it was because you just don't carry as much weight around here. Discrimination occurs when someone is treated less favorably due to a particular protected attribute, even if the treatment isn't open antagonistic. For example, not getting a promotion because you are pregnant, or being the subject of joking banter. By reference to that protected attribute, and even where it is indirect, for example, an employer may say they are open to employing people with disabilities but do not provide appropriate access. Harassment is when someone is treated in a way that is offensive, humiliating, intimidating, or threatening because of a particular attribute, like coming from another country. Sexual harassment is unwelcome and advances or attention of a sexual nature. Bullying is repeated unreasonable behavior that places the affected person's health or well-being at risk. Bullying and harassment are considered discriminatory behavior if they are motivated by a protected attribute of the victim, like a disability. The word discrimination is often used on a day-to-day basis to describe being treated unfairly for a particular reason, but unlawful discrimination happens when less favorable or unfair treatment relates to specific characteristics, non-legally as protected characteristics. The UK have 9 protected characteristics which are set out in the Equality Act 2010. There is no minimum length of service required for workers to be able to bring a claim for unlawful discrimination. For employers, this means that a claim for discrimination can be made in respect of a job advert throughout employment, up to job references for ex-employees and beyond. The UK have 9 protected characteristics set out in the Equality Act 2010. These are age, disability, gender, reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. Employers and employees can both be liable for acts of discrimination which happen in connection with work. In short, this means that a claim for discrimination can be brought against the employer as an organization, but that claims can also be brought personally against individuals. Sometimes employers can be liable for the acts of their employees, even though the employer did not set out to discriminate against anyone themselves. When this happens, it is known as vicarious liability. Vicarious liability may be avoided if the employer can show they took all reasonable steps to try to protect discrimination from occurring in the first place. Claims for discrimination are technically uncapped in the amount a judge can award due to the possibility of claiming for injury to feelings. This type of award is almost always made when a successful claim is brought regarding discrimination. Although the amount is uncapped, it is usually determined with reference to vendor bandings. There is a lower, middle, and upper band which guide how much should be awarded depending on the level of seriousness. The 4 types of discrimination. There are four main types of discrimination under the Equality Act: direct discrimination, indirect discrimination, harassment, and victimization. Whereby direct discrimination, there are three different types of direct discrimination. Direct discrimination occurs when a person is treated less favorably because of a protected characteristic they possess. This is ordinary direct discrimination. It is the only type of direct discrimination which may be lawful, but only if it is objectively justifiable. A protected characteristic possessed by someone who they are associated with, such as a member of their family or a colleague. This is direct discrimination by association. A protected characteristics they are thought to possess, regardless of whether the perception is correct or not. This is direct discrimination again, although there is normally a deliberate out or exclusion intentional. This means that even if discrimination occurred and unintentionally, a claim can still succeed. So indirect discrimination is usually less obvious than direct discrimination and is normally unintended. Generally speaking, it occurs when a rule or plan of some sort is put into place which applies to everyone and is not in itself discriminatory, but it could put those with a certain protected characteristic at a disadvantage. In law, it is where a provision, a criterion, or practice involves all these four things. The provision, criterion, practice is applied equally to a group of people, only some of whom share the protected characteristic. It is or will have the effect of putting those who share the protected characteristic at a particular disadvantage when compared to others who do not have the characteristic. It puts or would put the person at that disadvantage. The employer is unable to objectively justify it. The Equality Act does not define what a PCP is. I can say the term is most likely to include an employer's policies, procedures, requirements, rules, and arrangements, even if informal and whether written down or not. Although all four elements must apply for a claim to be successful, it would be the responsibility of the employee or claimant to demonstrate point and to demonstrate that point 3 applies to themselves personally. Harassment is unwanted conduct related to a protected characteristic. It must have the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Bullying, nicknames, gossip, intrusive or inappropriate questions and comments can be harassment. Excluding someone, not inviting them to meetings or events, may also qualify. To say the behavior was not meant to cause offense or was banter is not a defense. With harassment, how the victim sees the conduct is more important than how the harasser sees it. Someone who witnesses this type of conduct can claim harassment if it has had a negative impact on their dignity at work, even if they do not share the characteristic as the colleague who was harassed. Victimization. Victimization occurs when an employee suffers a detriment because they have done, or because it is suspected that they have done or may do one of the following things in good faith: make an allegation of discrimination, support a complaint of discrimination, give evidence relating to a complaint about discrimination, do anything else for the purposes of or in connection with the Equality Act, such as bringing an employment tribunal claim of discrimination. A detriment can include a loss, disadvantage, damage, or harm. For example, being labeled a troublemaker, being left out and ignored, being denied training or promotion, being made redundant. Lawful discrimination. When can discrimination be lawful? In limited circumstances: ordinary direct discrimination and indirect discrimination may be lawful if the employer can objectively justify it. The law calls this a proportionate means of achieving a legitimate aim. The employer must show that the less favorable treatment or PCP was appropriate and necessary. This must be objective and usually involve a business need. What is proportionate will vary from case to case and can also depend on the size and resources of the business. For example, a large employer with many staff may find it easier to approve flexible working requests, which may come mostly from women with childcare responsibilities, than a small firm may be able to if they only have a few staff. What is the difference between direct and indirect discrimination? Discrimination in the workplace can often be harder to understand than people might expect. Some might think that if discrimination was occurring in the workplace or they were the target of employment discrimination, they would be aware of it. When we think about discrimination and what it looks like, we might often think about direct discrimination. However, this is not the way it always occurs, both in the workplace and outside of work. Indirect discrimination can also affect many employees, but how is this different from direct discrimination? While indirect discrimination can be less obvious, it still negatively impacts employees and can make it difficult for them to perform their jobs. When direct discrimination occurs, a person is treating someone differently because of their association to a protected class. This could be because the employee is of a certain age, race, gender, has a particular sexual orientation, and more. Other employees who don't belong to this protected class don't receive this negative treatment, while employees who share these characteristics alone are targeted. However, direct discrimination doesn't mean that the discrimination occurring is always obvious. Direct discrimination can still be subtle and difficult to prove. Discrimination at work, even when it is directed at a person or group, doesn't have to be blatant, such as using slurs. Even when an employee experienced direct discrimination, they can still question whether they are actually being discriminated against while direct discrimination targets individual employees with certain characteristics. Indirect discrimination occurs when employees are all treated the same, but certain employees are put at a disadvantage because of this. In any workplace, there are policies that all employees are expected to follow, but not all employees are exactly alike. So this can end up being harmful to some. For example, there may be policies in place that requires employees to wear their hair in a certain way or avoid certain hairstyles. While all employees are expected to follow this, it can negatively affect people of different races who have their hair textures that don't allow for this. Another example would be requiring all employees to work on a day with significant importance for certain religious groups. All employees are required to do this, but it prevents certain employees from practicing a sincerely held religion. Employers may also not be aware that indirect discrimination is occurring if they don't consider the ways different workplace policies would affect employees in protected classes different from theirs. Indirect discrimination may not always be intentionally done, but it still harms certain employees. Just because a policy wasn't intended to negatively affect certain people does not mean that it isn't discriminatory or shouldn't be remedied. When you are facing direct or indirect discrimination, you need to ensure that your employer is aware. Ideally, your employer would take the proper next steps to stop these behaviors and actions from occurring, but this doesn't always happen. If you are suffering from employment discrimination due to your association with a protected class, it could be time to consult with an experienced lawyer who understands how to handle these complex matters. Direct discrimination is when you are treated worse than another person or other people because you have a protected characteristic. Someone thinks you have that protected characteristic known as discrimination by perception. You are connected to someone with that protected characteristic known as discrimination by association. Your circumstances must be similar enough to the circumstances of the person being treated better for a valid comparison to be made. If you cannot point to another person who has been treated better, it is still direct discrimination. If you can show that a person who did not have your protected characteristic would have been treated better in similar circumstances. To be unlawful, the treatment must have happened in one of the situations that are covered by the Equality Act. For example, in the workplace or when you are receiving goods or services, it is possible to be discriminated against by someone who shares the same protected characteristic as you. If you have been treated worse due to your age, this may be allowed if the organization or employer can show that there was a good reason for the difference in treatment. This is known as objective justification. If you are treated worse due to any other protected characteristic, it is unlawful direct discrimination, whether or not the organization or employer has a reason for it. Whereas indirect discrimination happens when there is a policy that applies in the same way for everybody, but disadvantages a group of people who share a protected characteristic and you are disadvantaged as part of this group. If this happens, the person or organization applying the policy must show that there is a good reason for it. A policy can include a practice, a rule, or an arrangement. It makes no difference whether anyone intended the policy to disadvantage you or not. To prove that indirect discrimination is happening or has happened, there must be a policy which an organization is applying equally to everyone or to everyone in a group that includes you. The policy must disadvantage people with your protected characteristic when compared with people without it. You must be able to show that it has disadvantaged you personally or that it will disadvantage you. The organization cannot show that there is a good reason for applying the policy despite the level of disadvantage to people with your protected characteristic. If the organization can show there is a good reason for its policy, it is not indirect discrimination. This is known as objective justification. Examples of direct discrimination are: a business is looking to hire a personal assistant. In the job application form, there is a question asking if the applicant has any disabilities that will make doing the job difficult. As disability is a protected characteristic, this question is against the law. The employer should instead ask all applicants if they need any reasonable adjustments to complete the interview or any part of the hiring process. All has a close friend who had a surgery. I said Ali has a close friend who had a surgery to change their sex. After some of Ali's work colleagues find out about the surgery, they stop inviting Ali to social events. This could be discrimination by association, as gender reassignment is a protected characteristic. Rehan is rejected for promotion to a supermarket buying team that sources wines. Or the employer believes Rehan is Muslim because of her name, and they would therefore not want to work with alcohol. This is discrimination by perception. Rehan is not a Muslim. In contrast, examples of indirect discrimination include: a business is recruiting for a head of sales. The HR team only advertises the job internally. The only people who could apply internally are all men. This means the business could be discriminating indirectly based on sex. Another example of indirect discrimination is a job advert for a salesperson says applicants must have spent 10 years working in retail. By doing this, the business could be discriminating indirectly based on age. This is because the advert excluded young people who may still have the skills and the qualifications needed. The advert should instead say that applicants need a specific type of experience and knowledge. It should also include the main tasks and skills involved in the job to show applicants what they will need to be able to do.